All right, let's go on the record. 19 CF 7518. I have counsel for the State Defense, Mr. Quiles, present. Good morning, everybody. We had a nice night. So after we concluded yesterday, I did send to counsel a preliminary look at the jury instructions. After I made some edits. The state did send a preliminary copy of the verdict forms as well for all three counts. This morning, I did go over some more of the jury instructions. If you noticed when I sent it to you guys preliminarily, there were some things highlighted in red. That's what I wanted to talk about. I did format the Williams Rule instruction accordingly. It's a bit different in this case, and there's two witnesses, and one of them testified twice. But in the copy I sent you guys this morning, I tried to clarify as best I could the Williams Rule instruction, so please take a look at that. Yeah. The lesser included charges for counts 1 and 2 being murder and manslaughter with a firearm. If you notice, I combined those two, and I'm fine, and I kind of spaced it out where I said, as to element 1, I said as to count 1, this is the element. As to count 2, this is the element, and I think what I need to do is, when I explain the lessers, tell the jury the only difference between the lessers for counts 1 and 2 is the name of the victim. That's the only element that's different. Maybe come up with some language, that way they know for sure that it's combined. I don't want them to have any confusion over that issue. And then on the verdict form, the state included, well, so those are the only two lessers for counts 1 and 2 is murder, second-degree murder, and manslaughter with a firearm as of right now. For count 3, sexual battery, in the verdict forms, the state included a lewd charge. Based on that, I assumed they wanted it included. It is a category 2. There are no category 1 offenses for the crime charged in the indictment. So the copy that was sent to you guys this morning does include that jury instruction. That's not to presuming that it will be included. That was just to kind of give the most information, and we can scale it back if necessary. Because category 2s are permissive compared to category 1, so I needed to have an inquiry with counsel about that issue. Other than that, the jury instructions are rather good to go, from what I can tell. But I wanted you guys to have a chance to look it over at a break and have a good conversation about it before we move forward. Is there anything else that you guys want to add that I haven't stated already?
No, at this time, Mr. No, Your Honor.
Is the defense requesting any other lessers for counts 1 and 2 or count 3 that are not already included in the preliminary instructions?
Can we give you that answer at the middle break?
Okay, fair enough. Depending on how
Judge, the one thing I did want to bring to the court's attention, as I was coming out of the parking garage, there was 2 of the jurors there. I did not say anything to them, but I have an obligation to let everybody know. One of them held the door for me because I couldn't get through the metal gate on my own, but I did not say anything to him, did not acknowledge, but I didn't want anybody saying I was trying to talk to a juror or do something I wasn't supposed to, so I wanted the court to be aware of that. That occurred on the way in.
Okay.
I mean, nothing was said. We didn't even look at each other. He just held the...
Sounds like he knew not to say anything. He or she knew not to say anything either.
Both of them wanted that.
Oh, there's 2 jurors. Okay.
But we didn't say anything. He just held it. I went by, looked away, and like we always do.
Okay, no problem. Is there anything I need to be aware of what's going on?
Yes, sir, Judge.
phone calls, you mean phone calls from the jail?
Last night after close of session, I received this just this morning, probably an hour. There's a comment that he made on a video visit. First name at the moment, Paulette, and he and his brother Joseph Quiles, and they talked, and then witness is currently to testify yesterday in support. Joseph apologized to his brother and responded with a laugh. Said that you, brother, that you meet society. That's the quote. Davis that was society quote. Several other comments about the testimony yesterday. What I would say to the court, I'm going to forward two separate emails, all discussions in the day last night about the testimony. I just wanted to make the first put it on the record and disclose it because again, there's not been a decision about it. It's about whether he's going to testify for this record. This is something that certainly is an acknowledgement that his brother did the right thing. It depends on work to pay his debt to society. And our position is one, now disclosing it to the defense. Number two, subject to cross-examination, that information. And number three, he denies whether that. This time, I'll forward both emails that both this morning within about an hour or so ago. I just got caught up on the red shortly before we started, so I will forward both of those.
Okay.
And just to be clear, the comment about the debt to society had to do with his brother prior. It is not even an issue.
It appears to be a comment about him testifying and his debt to society, but
Is there a video of it?
we'll get our hands on it.
Okay. I'm sure they'll turn that over. I'm sure they'll turn that over to you guys. Obviously, I'm assuming they want to see that before their client makes a final decision on that issue. And I'm sure the state will. I'm sure they got people working on that, if I had to assume. Is that fair, Mr. Skinner? Okay, so but not just the emails, but a copy of the video is going to be turned over to the state, to the defense.
Sending her an email as the court's.
Okay. Mr. Davis, you said you wanted to. Guys, we got to keep the noise down in the courtroom. If you got to talk to somebody, please go outside the courtroom. I'm still in session. Mr. Davis, you said you want to address any motions now at the end of the state's case this morning. You want to do that now?
Give me 1 second, please, Mr. President. Yes, sir, Your Honor.
Can you hear me okay, Your Honor?
Can.
Thank you. Judge, at this time, the defense would move for a judgment of acquittal, specifically as to counts 1 and 2. To start with, the state cannot prove a crime was committed without the statements of the defendant. Specifically, they cannot prove that it was premeditated or whether or not it was the heat of the moment or a crime of passion. They cannot prove where the crime actually committed, specifically that the elements of the crime, that IS and her unborn child are dead, that the death was caused by a criminal act of Johnathan Quiles, and that the act was premeditated without the defendant's wire statement or wire recorded statements that were on the by the jailhouse snitch. The detective, Billy Abbott, repeatedly stated when he was on the stand on cross-examination that the case turned from a missing person case to that of a homicide case based on the confession and the wire on the defendant. The alleged crime scene at Ace Pick-Apart is based solely upon the confession and the wire of the defendant, and that Detective Abbott specifically stated they could not prove premeditation of murder of IS and the unborn child until they had the confession and that was on the wire. Without Johnathan Quiles' statements on the wire, the state cannot show that a murder has occurred, that there was, in fact, a crime scene at Ace Pick-Apart, and that he had allegedly lured IS up there to a remote area of Ace Pick-Apart and ultimately murdered IS. All of that is based on, Your Honor, corpus delicti. Specifically, the state's entire case hinges and is based on, specifically, Billy Abbott's testimony stating that it's either the confession on the wire or his statements to his brother. As such, Your Honor, the defense would rely on, and I'm pulling it back up, forgive me, Judge, I got to pull up my case sites. I had everything pulled up, Judge, and I got kicked off the internet with where I had everything saved. This up real quick on yours. Mine won't do it. Or there was the JJ case. Judge, I need 1 second because I lost this.
Okay, I do have a jury waiting on me.
Specifically, Judge, the state's entire case hinges on and is based on Johnathan Quiles' statements, either on the wire or the confession to his brother. Based on this, in Williams v. State, 689 Southern 2nd, 393, and that is a Florida 3rd DCA case, 1997, and Burks v. State, 613 Southern 2nd, 441, specifically citing to page 443, that's a Florida Supreme Court case out of 1993, and it specifically goes into the state may offer into evidence admissions against interest to establish one or more of the elements as charged, but they must have independently established corpus delicti to prove that the defendant actually committed the crime and or that there was a crime scene to corroborate the state's version of the facts. In this case, Judge, there is no blood, there is no body, there is no murder weapon, there is no DNA, and only the wire and the confession to his brother tie Johnathan Quiles to this case specifically. Detective Billy Abbott specifically stated that without the defendant's statements, they could not approve this case. Judge, without that, there is no corpus delicti in this case, and as such, counts 1 and 2 specifically should be dismissed. Going to count 3.
Can I stop you there? What was the case you cited?
I have 2, Your Honor. The first is Williams v. State, 689 Southern 2nd, 393. That is a Florida 3rd DCA case, 1997. The second case, Your Honor, is Burks v. State, 613 Southern 2nd, 441, citing specifically to page 443. That's a Florida Supreme Court case from 1993, Your Honor.
Okay, go on to count 3 then.
As to count 3, Your Honor, that is based on completely circumstantial evidence of the fact that there may or may not be the defendant's DNA on the pair of panties. The FDLE expert said that his DNA was present, but could not definitively say whether it was a skin cell transfer or whether it was a serology transfer or semen. He said based on his the testing that he had, there was no definitive either way. Again, without the defendant's statements saying specifically on the wire that he had sexual intercourse with the 2 daughters, or excuse me, 2 nieces, that the state cannot meet their burden and prove their case. Again, that is corpus delicti, and I would cite the same 2 cases and ask to take that under consideration for the defendant's judgment of acquittal, Your Honor.
Anything else?
No, sir, Your Honor.
State.
Request to remain seated, Your Honor.
Sure.
Your Honor, the state of Florida would ask you to deny the judgment of acquittal. There is a line of cases. I'm going to cite something more recent than counsel has. Mackerley v. State, Mackerley v. State. It is a 4th DCA case from March 22 of 2000. 25 Florida Law Weekly, D as in dog, 722. Stands for the proposition that circumstantial evidence was sufficient to establish corpus delicti for murder, even though the victim's body was never found. And then it goes on, there's a lot of facts, just like we have in our case. In that particular case, Judge, under the corpus delicti portion of the opinion, just to make sure the record's clear, there are 2 paragraphs that are a pertinent note, and it reads as follows. They were basically the situation judges, they didn't object at trial regarding with respect to either nor argue it at a judgment of acquittal. The appellate court said even if they had preserved the issue, they went on to say this. Even if they had the issue preserved, we would conclude the state of Florida proved the corpus delicti of the murder before Mackerley's confession was admitted at trial. Murder cases in which the body of the victim is never found frequently invoke questions concerning whether the corpus delicti of the crime had been established prior to the introduction of a confession or admission. It cites Myers v. State, 704, Southern 2nd, 1368, a a Florida Supreme Court case out of 1997. Also Bassett, 2 S's and 2 T's, v. State, 449 Southern 2nd, 803, a Florida Supreme Court case out of 1984. Goes on to state, as the 5th DCA aptly pointed out in Lindsay, State v. Lindsay, Lindsey, 738 Southern 2nd, 974. That case reads as follows. The term corpus delicti does not mean dead body, but is more properly defined as the body, foundation, and substance of the crime. The Florida Supreme Court has embraced a 3-part test to establish a corpus delicti for murder: the fact of death, the criminal agency of another person as the cause thereof, and the identity of the deceased. In proving corpus delicti, circumstantial evidence is sufficient, and proof beyond a reasonable doubt is not necessary. Again, we're talking about at the JOA, had they objected stage. Obviously, we need to prove it to this jury beyond a reasonable doubt. And they cite, in that particular opinion, SOCOR v. State, SOCHOR v. State, 619 Southern 2nd, 285, a Florida Supreme Court case out of 1993. In this particular case that I'm citing for the court, it reads as follows. Mackerly contends that the state failed to establish a corpus delicti of homicide because the state did not demonstrate that, they named the victim, was dead, and that his death was the result of the criminal agency of another. In considering this argument, it is important to note, to establish a corpus delicti, the state is not obligated to prove the specific manner in which the victim died, nor the identity of the person who committed the homicide. Burks v. State, 613 Southern 2nd, 441, Florida Supreme Court case out of 1993. The state need only present some direct or circumstantial evidence tending to show that the victim is dead and the death was a result of criminal activity. Once the state has presented prima facie evidence of the corpus delicti, the state may then introduce the confession or admission against interest to show that the defendant is the perpetrator. In this case before the court, Your Honor, the defendant, it's not just this wire. There are a load of Snapchat messages from the defendant to the victim that this jury listened to that showed this ongoing relationship and this how enraged the defendant got. All those statements are they're not on the wire. They're confirmed by the wire. But all those Snapchat statements, Your Honor, were establishing sort of a relationship, establishing this was the only person she was in this relationship with. They were establishing that this is who Jose was. They were establishing that the victim herself, IS herself, Your Honor, was trying to leave him. They established numerous things before we even ever get to the wire. Furthermore, the evidence very clearly shows them meeting up. He turns his geolocation data off at the same time she's leaving Terry Parker High School. Haley Schimpert testified she saw him pick her up. That's connecting them. That's putting them together. That's showing that when she disappears, she's with him. All this evidence that we put forth showing that she no longer exists, her bank statement, family, her last work at Chick-fil-A. She didn't even pick up her checks. We established she did not exist on the face of this earth. We established that when she disappeared, it appeared to be she's walking off school grounds, never to be seen again by family, by friends, by phone. Her phone goes off. All the things that we're able to show to establish she's deceased. This is foul play. This is nothing she did consensually. And here we are 4 years later, she's and she's never to be seen again. The state not only establishes that, but absent any wire, the state also shows in corroboration of the wire prior to the wire ever even happening, he's telling his brother. He's giving his brother, he calls his brother and confesses, which again, as the court knows, we put all 3 of those confession witnesses on at the very end of our case, having established all these other facts that show this is foul play, she's gone, she disappeared off the face of the earth. The case law supports the proposition that circumstantial evidence does warrant proving corpus delicti. In this case, to answer that proposition, we'd ask the court deny, and for the same arguments with respect to the sexual battery, deny the JOA with respect to counts 1, 2, and 3.
Counsel, how do you spell Mackerly again?
Mackerley.
That was March of 22.
Yes, sir. March 22 of 2000.
I'm sorry, I misunderstood you.
Yes, sir.
I think is it a fourth ECA?
Yes, sir.
Okay, I found the site. The March date threw me off. It's actually, I think the main date came down on April 2nd. The case is 294 Southern 3rd 311, fourth ECA. I'm sorry, that's not the case. My apologies.
I can give the court my copy. I've got a hard copy as well.
No, it's okay. I'll find it.
If I may, Judge, just briefly,
Oh, yes, sir, of course.
in Burks v. State, I agree with everything that the state said, except the state has the burden of proving by substantial evidence, and this is a quote in Burks, that the state has the burden of proving by substantial evidence that a crime was committed, and such proof may be in the form of circumstantial evidence, but it cannot be just mere evidence to show that a crime is committed, and it need not be proven beyond a reasonable doubt. But in this case, specifically to differentiate, Billy Abbott specifically said that without the defendant's own statements on the wire, he had no knowledge that a crime had been committed and that she was dead. As such, he admitted there was no blood, no body. He couldn't confirm as to what was the murder weapon, and there was no DNA found other than on the panties, and he couldn't say if that was in the commission of a sex crime or not. And then he based everything solely on the wire and the confession of the defendant to his brother. That, Your Honor, is failing to meet the grounds for corpus delicti.
Is it March 22nd, 2000?
Yes, sir.
Site 754 Southern 2nd 132. That decision looks like it was quashed by the Supreme Court. It looks like it was a wholly separate issue, though.
Yes, sir. And
Court opinion.
if you go to that third,
Yeah, let me get the site on the record, Mr. Skinner. The site for the Supreme Court case is 777 Southern 2nd 969. Looks like the issue on appeal was a general verdict for first-degree murder on dual theories of premeditation and felon murder. That was the issue on appeal that was certified by the ECA Supreme Court. I want to make sure, even it's a red flag in Westlaw, to see a red flag, your eyes perk up a little bit. But it looks like the issue that was addressed is a separate issue than what's being discussed here in court today regarding the JOA issue. So I just want to make that clear. So it's not an issue on appeal.
yes, sir, thank you. And the reason we're citing it is because it lays out that line of cases that stand for the proposition that is good law. I cited Bassett and Myers and Lindsay and Socor, Sochor, Drysdale, all the cases that I read when I was going through the body of the opinion, stand for the proposition that even the defense agrees is good law.
I do. The light most favorable to state the JOA is denied. Can you bring the jury back in now?
Right. And while we're doing that, we just need to out 33B. There was an issue with the disc when we had put it in, and we have a new one that actually works properly. It is the second part of the defendant's cell phone dump.
Defense?
Sorry.
State's asking to replace 33B with a working CD.
No objection.
Okay, you go ahead and take care of that. At this point, what I'm probably going to do is not give the jury a mid-morning break. I'll go straight to a lunch hour, take an earlier lunch, and see where we're at.
One moment, Your Honor. Sorry.
Yeah. I agree. Judge, for purposes of, rather than stopping, taking the jury out, do you want to inquire of our client now as to whether or not he wishes to testify?
Does the evidence that the state mentioned this morning change that analysis at all? That's why I was going to wait. But if it's not changing the analysis,
They've had a chance to talk to him, Your Honor. We prefer court required now, and then they could, once they put on, I think they're putting on 3 witnesses, and they can rest, and we can move on.
You can do the inquiry now.
okay. Quiles, can you raise your right hand, please? Do you swear or affirm tell the truth, the whole truth, nothing but the truth? All right, sir. So we're at the stage of the ball game now where the state's rested their case in chief, and now I turn to the defense. Obviously, as you heard me tell the jury during jury selection and throughout the trial, the state of Florida bears the burden to prove the case beyond a reasonable doubt. The defense does not have to do anything, does not have to call any witnesses, etc. You have an absolute right to remain silent, and I'm going to talk to you about that. You have a constitutional right to remain silent. If you decide not to testify, the court will instruct the jury that the fact that you do not testify is not to be considered by them in any way whatsoever in their deliberations. And if you recall, we talked about that in jury selection, and I gave an example of that. If you choose to testify, the court will instruct the jury that the testimony is to be considered like the testimony of any other witness. If you testify, the state will cross-examine you and ask you, if applicable, if you are a convicted felon, and if so, how many times. My understanding is that you are not a convicted felon and do not have any convictions for crimes of dishonesty, so the state is not able to ask you that question because they don't have a good faith basis to ask you that question. Is that correct, defense? State?
Yes, sir.
As you saw throughout the trial, a couple times it was mentioned, are you a convicted felon? If so, how many times? That line of questions will not be able to be asked of you because it's not pertinent to your testimony since you do not meet that criteria. The right to remain silent belongs to you and to you alone, not to anyone else, including your attorneys. Your attorneys can give you advice and their opinion, but the decision whether to testify or remain silent belongs only to you. Have you discussed all of this with your lawyer?
I have.
You need more time to do so.
No.
And what decision have you made regarding testifying?
I'm not going to testify.
Is this decision being made voluntarily?
Yes.
Has anyone forced you to make this decision?
No.
Coerced you?
Nope.
Pressured you?
No, sir.
Threatened you in any way whatsoever?
No.
And you've had ample time to talk to your attorney about this decision?
Yes.
You seem rather confident in the decision.
Yes.
Is there any inquiry you want me to make addition to that regarding his decision not to testify at defense?
I know yesterday you mentioned argument just about in general.
Correct.
Has been done, but as far as that goes, no.
Okay, so I'm putting aside the decision not to testify. I'm going to move over to another line of questionings. But there's nothing else you want me to inquire about specific regarding his decision not to testify? Okay, so the court is making a finding that his decision not to testify has been made freely and voluntarily, and the court will instruct the jury regarding his decision not to testify at the applicable stage of the proceedings. So, Mr. Quiles, it sounds like your defense attorneys are calling a few witnesses to testify on your behalf. I have a general knowledge as to what they're going to say. Obviously, you have more in-depth knowledge than I do at this ballgame because they've talked to you about all this. Have they located the witnesses that you want them to locate to call on your behalf at trial?
Yes.
And you're in agreement with them calling these witnesses to testify on your behalf?
Yes.
And I believe there's 3 of them?
Yes.
Okay, and you're in agreement with that?
Yes.
There's no additional witnesses that you want them to call that they are not calling, is that correct?
You couldn't find the other one, so.
We talked the John Smith and the Larry?
Correct.
Well, I think the John Smith issue got debunked by the states.
Well, the issue is, Judge, actually during the course of the trial, it popped up in the phone record. It's not John Smith. It's a different name. It's John Anthony. So it popped up during the course of the trial. The state did provide information. We did attempt to follow up. But given that the person's out of state, we are unable to complete our follow-up investigation and produce that person. But it was not a John Smith. It turned out to be a John Anthony.
Have you talked to him?
We have not been able to reach him.
I did call the phone number that was provided by the state. I did not reach him. It was late last night, Judge, so he may call back today at some point, but at this point, he's in, I believe it was Georgia, if I'm not mistaken. Yes, okay. He's in Georgia, and so the likelihood of being able to provide him here, at this stage, it's...
Do you know what he allegedly would say? He was a co-worker at the Ace Pick Park?
We have no idea, Judge. That's the whole reason.
The expectation, Judge, would be that Our understanding is that he is on some of the video that the jury observed of him at work. He was with another gentleman during a portion of that video. That gentleman worked with him throughout that day. And so I don't know exactly what he would say specifically, but we would expect that he would provide information as to observations he made of Mr. Quiles that particular day.
Well, there are quite a few people who worked at ACE on that day. We can all agree to that, right?
Of course, but this...
And none of them are being called to testify.
No, and this particular person is someone who worked with him on a regular basis, and so this is someone who might remember that particular time. I think we did reach out to try and figure out if there were other people who may have worked with him, but we just could not find anybody who remembered that particular time. So,
Because to them it was just a regular day. There was no reason for them to specifically remember this day.
correct, and so they couldn't provide us with any information that would be something to put in front of a jury. Other
Okay.
than speculation of, oh yeah, I don't remember anything abnormal, which I believe both of the Lindros testified to that. So I don't think there was anybody else out there that we could have. This person in particular that Mr. Quiles requested us to try to find, he believed would have a little bit more direct information as to where his movements and activities throughout the day. Not knowing that name, of course, Anthony versus Smith, that obviously impeded us from being able to fully investigate that prior. And we literally received that towards the end of the day or middle of the day yesterday. So it's not like we had a great amount of time to do any additional legwork.
Okay. And then Larry was the other person that had no last name.
We did figure out Larry. Larry was the supervisor that's been discussed as having been on leave during that time period. He was not present during any of those days, so we did not pursue calling Larry, although we did have the information for him, and we did discuss that with Mr. Quiles.
Okay. So the only issue being John Anthony.
Correct.
Okay.
Judge, we just want the court to be aware, as well as we told our client, we've literally made every effort to make sure no stone is left unturned.
Understood. So Mr. Quiles, going back to you, sir, you're in agreement with these three witnesses being called on your behalf, correct?
Correct. Yes, sir.
Okay. And so when I asked you about any additional witnesses, it was the previous issue that we discussed regarding John and Larry.
Yes.
Other than that, is there any other issue or witnesses you want your attorneys to call to testify at your trial?
No, sir.
Have they done everything that you asked them to do in this case?
Yes.
Obviously, throughout the course of the trial, I've noticed that you've taken extensive notes on a legal pad. I've seen you talk to Ms. Michelle and Mr. Davis quite a bit. You've been engaged throughout the entire trial. You've taken quite a bit of notes from what I could tell. I don't know what you're writing, but you're writing something. And you've been conversing, ripping papers up, giving to your attorneys to ask questions, I'm assuming, of certain witnesses. Have they been engaging with you throughout this entire trial?
Absolutely.
And they've been taking your advice of issues that you want them to address?
Yes.
And you believe that they've done a good job for you?
An excellent job.
Good to hear. So I'm assuming based off that you're satisfied with their services here at this trial.
Yes, I am.
Is there anything else you want to bring to my attention?
No, sir.
Has anyone told you how to answer my questions here today?
No.
Anything else the defense wants me to inquire about?
No, Your Honor.
Anything the state wants me to inquire about?
No, Your Honor, thank you.
Okay, so at this point, we'll go straight through the morning. We'll take an earlier lunch. We'll see where we're at, if there's a rebuttal case or not. But if not, we'll start closings this afternoon after the lunch hour.
Judge, could I inquire, when you had the clerk come get me, I was in speaking with one of the witnesses in the conference room. As the jury's coming back in, can I go finish up with him to make sure he's ready and on deck to be called when Ms. Michelle's ready?
He's not the first witness?
No, he's going to be the second witness
So you want to talk to him in the interview room while Ms. Michelle is inquiring?
of the first witness that she's going to call, yes. Just so that we have
Okay.
ready to move him straight to the chute and ready to call.
The staff can accommodate you. I'm sure it can happen.
Thank you, Your Honor.
Okay. Any reason why we can't bring the jury in?
No, Your Honor.
Defense?
No, Your Honor.
Okay. Let's bring the jury back in, please.